Hey everybody, welcome back. I am just waiting for Triple L to join us. I am streaming on Facebook too. Looks like it's working so far, but if you're on Facebook, I don't know if I can see your comments here, so bear with me. I might have to go look at my phone probably to follow the comments. Let me see. Oh, it says I can view on Facebook. Let me see. Okay. Stop. Okay. Well, I am streaming on there. I think at some point I'm going to get it. Right now it's just streaming to my own Facebook. And I think what I'm going to do eventually is create a channel on Facebook just for Willow's True Crime. But that might not be for a little bit down the road. Let me see the status of Triple L. Okay, while I wait for her, so let's see. On the last one, we went over a brief timeline. We went over the search warrant affidavit. This is for Kouri Richens, who was married to Eric Richens. And she is accused of poisoning him to death in March of 2022. She was subsequently arrested about a year later in May of 2023. She is set to go to trial end of February of 2026. But the prosecution alleges that she poisoned his drink. She had made him a Moscow Mule, poisoned that drink with fentanyl, which was like 5 times the legal limit or something like that. It was, or 10 times, I can't remember. Possibly as a financial motive. She had done some sketchy things in the past. And I believe she's charged with some financial crimes, which we'll go into later. Let me think, what else? Yes, we went over her first court appearance. Okay, what's going on here? Okay, so yeah, Triple L might be just a few more minutes to come on. But today, what I think we're going to do is go over a little bit more of the timeline. And I have a video of Ronnie Darden, and he explains why he thinks his sister is innocent. Then we have an email to go over where Kouri Richens had written an email prior to her arrest to the Summit County Sheriff's Office trying to explain her quote-unquote exotic vacations and her supposed husband's alleged affair. I was going to go try to see if I could find some more information about this, but the sister of Eric Richens claims that Kouri had attacked her. I was able to just find a clip on it from Court TV, which will play that. We have a video for the walk the dog letter, and then a court appearance, a brief court appearance, because Kouri had requested the case to be dismissed. Let me see what I have on that. Okay, so I think that might be all for the day. My apologies for not getting on yesterday. Yesterday I wasn't feeling so well. For those who don't know, I'm on Ozempic, and it makes me pretty sick sometimes. And with the fibro, it kind of takes everything just out of my body. So that couldn't happen yesterday. Today I'm just feeling a little out of sorts. So I'm hoping Triple L can come on and help keep me in check, I guess. And hopefully maybe Freddie is ready, will join us at some point. Oh, I need to get Triple L's YouTube link for you guys. Hang on, let me grab that. She does have a channel, and I want to have people go over there and subscribe to her. If I can find it. Oh, that's not it. Bear with me here. I think she's got it under Triple L Mega, maybe? Oh, I know. Hold on. Let's do this. There it is. Triple L _ Mega. Okay, there we go. All right, so what I'm going to do is I'm going to start going through the timeline here a little bit. Let me get my screen shared. Here we go. And we'll kind of go where we left off. Okay, so we'll start. Let's see. I'll start a little bit behind. So we'll do February of 2023. This is prior to her arrest. She wasn't arrested until May. So February of 2023, Kouri filed a claim against Eric's trust, contesting Eric's sister as his personal representative of his trust. In April 19th of 2023, Kouri emailed Summit County to explain her quote-unquote exotic vacations since her husband's passing, his alleged affair, her mental health, their lack of financial problems, and her work ambitions. And so what I'm going to do is pull up that, and we'll go over that real quick. Okay, so again, this is prior to her arrest. So Kouri Richens writes email prior to arrest explaining exotic vacations, husband's alleged affair. Prior to Kouri Richens' arrest on May 8th, the Utah mom and children's book author accused of killing her husband sent an email to officials to quote-unquote clarify a few of their questions, according to court documents. On April 19th of 2023, Richens allegedly sent an email to Summit County authorities to clarify some points she had previously discussed. Detective Jeff O'Driscoll, the lead investigator on the case, was carbon copied on the email. In the email, Richens addressed her exotic vacations since her husband's passing, his alleged affair, her mental health, their supposed lack of financial problems, and her work ambitions. The letter also provided contact information for her previous nanny, who said she could give information on her family, saying, "If anyone can tell you about our marriage, it's her. She lived with us. Feel free to call her." Now, she also, by the way, has a former friend, or I guess I would say a former housekeeper / friend. That is the one that they believe is the one that provided her with the fentanyl. And I believe that that person's testimony is in question. They had made a statement to police however many years ago, and then have recanted, and then as of this month it was in dispute whether or not that was going to be allowed in. So we will be going over that probably on another next live or two. So in the letter, Richens addressed claims of exotic vacations, saying she took 2 trips last year, one because her kids qualified to play soccer in Spain, and another to go on their annual trip to Mexico. She said it is not new for us to go to Mexico or for us to go out of the country or on a vacation with our kids. She then wrote about Eric's alleged affair, saying it was not true that she had ever moved out. Rather, she said she took a weekend away to make sure it was clear if she would leave, she would leave if he did not end things with this other woman. She said they then figured things out like most couples do and went to counseling together 4 times afterward. Richens then wrote about her mental health, saying she had postpartum after her second child in 2014 and had taken medication for it. She then addressed finances, saying they had never had financial problems during their marriage and that she had not been financially reliant on her husband during the last 5 years. Well, she was also, by the way, committing some financial fraud from the sounds of it. I don't know the entire details of it, but she was signing his signature on a loan. Finally, she addressed how her husband had not wanted her to work as his first wife had allegedly cheated on him with someone at work, and he preferred the typical conservative life with a homemaker wife. However, Richard said that was not her personality and said she later started a business. And while it took some adjusting, she said, we hired a nanny and everything worked out. Richens finished her letter with the following statement. Happy to clarify or provide anything else you may need. I just want this over. I just want our lives back and to move on and grieve and mourn my husband without looking over my shoulder constantly for you guys or the idiotic private investigator or the Richens family. Oh, good Lord. Whatever I can do to help close this out, just ask. I'll give you or tell you whatever you want to know. Please check with the lab on those gummies. While Eric Richens was not a known drug user, information presented by the state at Richens' bail hearing on that Monday showed that occasionally Eric was known to have taken THC gummies. At that hearing, Richens was denied bail during her pretrial period. Richens has also been accused of poisoning her husband, Eric Richens, with fentanyl. She was arrested approximately 3 weeks after this email in the court documents was sent. And then the court says meeting again for June 22nd, rescheduling conference. And let me see if I have a status here on Triple L. Okay, looks like she's having some internet problems. She's not able to get on at the moment. Okay. She's got some high winds happening where she's at right now. Let me see if I can make this any bigger. No, doesn't look like it. Okay, so from Kouri Richens, sent Wednesday, April 19th, 2023, to Chad Hoffmeyer, Frank Root, and she CC'd the detective Jeff O'Driscoll. RE clarification. bring this up. It says, hey there, I thought I would clarify some other items on your list that you spoke to blank about. The beginning of February last year, my kids had a soccer tournament in Mesquite. The day before we left, February 2nd of 2022, that was prior to him being murdered, they tested positive for COVID. She tested positive for COVID. I have attached the picture of my test from on my counter in my kitchen from when I first found out. I had sent it to my mom and blank to let them know because I was just around both of them. Eric was the coach of the soccer team, and I'm the annoying mom on the sideline that never stops yelling. We don't miss games or tournaments. We're a huge soccer family. When we found out I had COVID, I didn't want to miss the soccer tournament, nor did I want to get my kids sick, so I stayed at Casablanca. I didn't want to risk getting my boys ill during the tournament and then not play well. I brought a box of at-home tests with me to test every day so I could either join the boys stayed at my father-in-law's or at least be with them during the game. Casablanca is about 5 minutes from the soccer field. Actually, here's a picture of the room number I stayed in. I had taken a picture for my mom and Eric. I was still positive every day. Pictures are attached. I would take pictures of my test to Eric to say, still positive. You can check Eric's phone for this. I stood on the sidelines wearing a mask and not interacting with anyone. Happy to get other soccer parents to attest to this. Eric had gotten COVID after we got home from Mesquite. You asked blank about my exotic vacations I have taken since Eric's passing. I went on 2 trips last year. One, my kids tried out at a soccer camp in Salt Lake City to qualify to play in Spain in June, and both my kids made it. So yes, I took them to Spain in October of 2022. I have attached their invitation letters. Also, Eric and I went to Mexico every year, sometimes twice. We traveled a lot. We have taken the boys to Mexico a few times. We like to go in January. So she goes from every year, sometimes twice. They travel a lot to, we took them a few times. Okay, whatever. We like to go in January. However, January of 2022, we could not go because Eric had his hunting trip to Mexico, trip to 2 weeks planned, and it was too much that month. This is not new for us to go to Mexico or for us to go out of the country or on a vacation with our kids. I took my kids and my mom came with us in August of 2022 to Mexico. So that was after his passing. As I hope you understand, the months prior to this, since Eric's death, have been hard to deal with. But you go on vacations. No, I have never been to Key West or the Keys in Florida. However, my nanny went with her family in June of 2022, so maybe you have something mixed up. Eric's affair was the same year I moved out. Excuse me. I moved out. The trust was created. I moved out. The trust was created as well as him looking into a divorce. I never actually moved out. I moved my clothes out one weekend to make Eric understand I'm not kidding about leaving him if he doesn't end things with blank. I did this on a Thursday or Friday while he was out of town, and I was home Monday. I never stayed another night at that other house. Eric and I figured things out like most couples do. Blank was her name. He changed her name in his phone so I wouldn't know about it. And honestly, we worked things out after that. And after that, I never went through his phone again to see if he changed it back. But you have his phone and could check. Eric and I went to Blank counseling in Camas, 801 Blank. We only went about 4 times. Maybe it wasn't for us. One moment here. Okay. Blank and Blank are the same person, as I'm assuming you know that. Haha. I'm also assuming Blank told Woody her husband got a call from him and gave all this information. Laugh out loud. Yet he didn't ever go in to talk to detectives. Ironic how these things work. Mental health. Yes, I got postpartum after my second child in 2014. Yes, I took medication for it. No, Eric and I did not have financial problems ever. Yes, Eric made more money than me. Do you make more money than your wives? Have I ever been financially reliant on Eric in the last 5 years? Absolutely not. But yet she was, taking out a loan or two without his knowledge. Eric did not want me working because one, his first wife cheated on him with a guy at work. Two, and a long blank, I don't know what that is. Three, Eric wanted us to live the typical conservative life where the man takes care of his family and the wife is a homemaker, wife, mom, and that's it. That's not my personality and not the way I was raised. I am very independent, even when I stayed home with my kids in the last few years. I was in grad school for years because I wanted to be more and do more than be a homemaker, and I did. And when I did and started my business, which I believe she flipped homes for a living, it took some adjusting, but Eric and I were fine with it. We hired my nanny and everything worked out. My nanny, blank, phone number blank, moved out because she was engaged and she and her fiance were moving in together. That was always supposed to be temporary. She's worked full time for Eric and I for years prior to his death. If anyone can tell you about our marriage, it's her. She lived with us. Feel free to call her. Blank has already submitted her phone records to you to prove that your troll is incorrect. Whatever. Blank will also be submitting hers over to you guys today or tomorrow. I am working on getting mine. However, Eric's business partner is not cooperative, but you can call Blank and ask for them, and he would probably give them to you at their blank phone number. I know what time I went to bed that night. There is no quote unquote hole in my story. Hopefully, by obtaining 4 phone record documentation, you guys can see this too. And they did receive documentation, a lot of phone records, really implicating you, especially with your mom. Happy to qualify or provide, or happy to clarify or provide anything else you may need. I just want this over. I just want our lives back and to move on and grieve and mourn my husband without looking over my shoulder constantly for you guys or the idiotic private investigator or the Richens family. Whatever I can do to help close this out, just ask. I'll give you or tell you whatever you need to know. Please check with the lab on those gummies. P.S. Chad, I hear you also know our good friends blank. Their son and my son play on the same soccer team. When Eric passed, blank took over coaching. You guys could even chat with them if you feel necessary. Signed, Kouri Richens. So there's that. Okay, let me go back to the timeline here. So May 8th of 2023, Kouri was arrested for aggravated murder and 3 counts of possession of drugs with intent to distribute. June 9th of 2023, Kouri filed a civil lawsuit against Eric's estate, alleging she deserves several monetary and or physical assets according to their prenup. August 18th of 2023, the state of Utah announced it will not seek the death penalty in its prosecution. This decision was made in careful consultation with Eric Richens' family and his 2 sisters, who are Eric Richens' personal representative and victim representative, respectively, stated court documents. According to court documents, this means Kouri's charge of aggravated murder is now a non-capital first-degree felony and is punishable with 25 years to life in prison if she is found guilty. All right, so here we go into the walk the dog letter. So September 18th of 2023, a document often referred to as the walk the dog letter surfaces, in which Kouri appears to be telling her family members how to testify in court. Prosecutors said the letter was blatantly witness tampering and filed a motion to prevent Richens from having contact with family members. And we went over the walk the dog letter in the last video if you want to go ahead and take a look at that. It is pretty damning. She pretty much, the letter was addressed to her mom, and she is telling her mom how to tell her brother what to say to the lawyers. So September 9th of 2023, Kouri's attorney says the walk the dog letter is actually part of a fictional novel she is working on about her fictional stay in a Mexican prison. You can very much tell that the whole thing is very much a story, which I didn't get that. But also in her defense, Kouri is an author. She did write a book about grieving, a children's book about grieving after her husband's death. On October 11th of 2023, Kouri's attorneys file a motion to dismiss her case based on the walk the dog letter going public, claiming it violates a gag order set up by the court in May. It asks that the trial be moved to Salt Lake City instead. October 12th of 2023, prosecutors say they want the entirety of Kouri's Walk the Dog document, which Kouri and her attorney insist is part of a larger fictional novel. They petition the court, asking the defense to hand over the document. The 2 sides disagree over whether or not the prosecution has a right to see the document. Prosecutors say fictional works are not protected under the attorney-client privilege. And then so I have that from Court TV, which I'll go ahead and show that we'll go over. So one moment. Come on, share screen. Here it goes.
To address questions, or if you want to stop me midpoint and ask questions, however the board wants to proceed with that.
Perhaps I can begin with a threshold question, if you don't mind.
Yeah.
In order to grant the motion, I have to make a finding that some kind of conduct by the state's counsel rose to the level of a denial of due process or the denial of a right to a fair trial, right?
Correct.
A lot of that conduct you cite in your motion has to do with letters and filings made after a search of Ms. Richens' cell and statements or allegations regarding witness tampering or the danger thereof. But what if they just amended the information and brought charges for witness tampering based upon the same searches and the same evidence? And I use evidence loosely. I'm not suggesting that anything's admissible or wouldn't be subject to a motion to suppress. We'd be right where we are right now, but I don't think that would be misconduct.
I don't think so either, and here's why. If they had formally charged her, she would be given due process rights as it relates to the alleged witness tampering, right? We would be able to cross-examine people, she would get a trial, we'd be able to present witnesses, we'd have arguments whether or not evidence was going to be admissible or inadmissible. The problem with the way the state has characterized this in their briefing is the fact that they have definitively said she's guilty of it without being afforded any of those. And I think being charged with something is different than the state saying she witnessed tampered. This isn't the first time she witnessed tampered. This is further evidence of witness tampering, all of those things. And then they go on to say, not only did she witness tamper, but because she witnessed tampered because she's guilty of murder. Like her witness tampering is a consciousness of guilt. And I can pull it out of the briefing. We prepared it in slides, but that's the problem. And that's the violations of rules 3.4, 3.6. And then
And just an FYI, this was her attorney at the time. I don't know why yet, but at some point, this attorney either quits or she's fired. And I'm not entirely sure why, but we will figure that out as we go along.
Standards is you can allege some through a filing or through a criminal complaint, right? She's here today because the state's alleged that she committed a number of crimes.
Sure.
Right? And she's going to get a preliminary hearing, and we're going to go through this entire process before we get to say she's guilty or not guilty. And the problem with the state's characterization over and over and over again, and in fact, it got progressively worse or progressively more definitive in their statements that she is guilty of witness tampering, and that's the narrative that the media has picked up. And I think that's the violation of the rule, not, if they had charged her with it, you're right, we would still have to deal with it. And perhaps there would be some press surrounding it. But we would also then have the opportunity to refute that or go through due process rights. But by just saying she was guilty of it, and by saying she was guilty of it is bad. By saying she witnessed tampered as a consciousness of her guilt is worse. By saying she administered the fatal dose of fentanyl is worse.
So
and they're tying all of this together.
A lot of that water went under the bridge as of the detention hearing. That is their theory of the case, that there was a financial motive, there was poisoning, caused the death
right.
of her spouse. I mean, that's the case. Then we have requests for things like don't let her talk to certain individuals because, and then once we get into because, their justification for the request is, we're concerned that she's trying to alter their testimony at a future trial. Stated broadly, everything I just described is part and parcel of lots of criminal cases.
Right, except for the fact that they go further to say, they have a theory, right? It's in the probable cause statement, it came out in testimony at the detention hearing, you're right. That happens in every single criminal case, and we can cross-examine people and weigh the credibility of witnesses as we go through, okay? The problem is in their briefing, they dispel or they characterize the defendant's alternative theory or perhaps the potential theory of the defense as a false narrative, that it's a lie, okay?
Sure.
Which completely diminishes the credibility of anything we say. And then they've gone on to say, and all of her witnesses are lying, and she's telling her witnesses to lie. So now we're in a position where anybody we put up there, you know, a jury pool is gonna say, well, I mean, she witnessed tampered, so obviously these people are lying. And the state's already said that anything she says is a false narrative because it doesn't fit their theory. That's a problem, and the rules specifically prohibit the state from commenting on the theory of the case, or on alternative theories of the case, or on the credibility of witnesses. And
Trying to determine where the line between permissible advocacy and impermissible communications that would irreparably damage the jury pool. I acknowledge that however long jury selection was going to be at the end of the detention hearing, it seems like it's 3 times longer now. I'm with you. I got it. But why can't we, through a combination of
It does take a long time for jury selection, for sure.
and instructions to whatever jury gets selected, mitigate the harms that you're describing?
I'm gonna answer this in 2 ways.
Sure.
Okay, the first one is, I wanna address first is the rules are clear about what they can and can't do. And the rules are clear about prosecutors in particular, what they can and can't do. And they have a heightened duty. And there's case law out there that specifically says they have this heightened duty because things that come from the government come with more indicia of credibility, right? If the government's saying she's a liar and the witnesses are liars, and any theory she has of the case is a false narrative because it doesn't fit theirs, that's a violation of the rules, like period, I think. Or at least that's our position, is they have clearly violated the rules in doing that. And in going so far as to make statements about her guilt. There's been a violation of the rules. I think what you're getting to is the potential remedy, and I think the prejudicial effect is that this is everywhere. We pulled, I mean.
But it was everywhere long before
It
this.
was, but it was everywhere before the state started making these comments. It was going to be everywhere. I don't think, I mean, I'm not gonna sit here and say that, this wouldn't have happened, or there wouldn't have been news stories, sure. There would have been news stories about this case no matter what we did, and I think that's a given. The problem is now these news stories have adopted the state's interpretation of the letter, and the news stories have run with.
I mean, I have assiduously tried to avoid news coverage of the case,
Right.
just to make sure that my consideration of it wasn't polluted by any inaccuracies in the popular media. But even I've bumped into the cover of People magazine, which seems to indicate, or have at one time been providing a counter.
This is a big case, so yeah.
By the defense side of it. I mean,
I think
why isn't this a case
The
where both
national
sides
media is on it.
hearing their competing narratives to the fullest extent they believe is permissible under the rules?
I think you can advocate, but I think it has to be within the rules. And when you go so far as to essentially say she's guilty of witness tampering, and because she witness tampered, she committed murder, and the Today Show pulls a snippet and puts it by her face that says she told these people to lie about whatever it is, that's a problem. And I think that goes a step too far. Yes, we can all effectively advocate. We're gonna do it through briefing throughout this case, I'm sure. But I think there's a line in what you can say, and I think the rules are very clear on it. And when the state starts making conclusory statements about her guilt, about the credibility of her witnesses, about her credibility, about my credibility, I don't think, and then the narrative becomes, and the comments that we pulled are, she's guilty, she's, why are we even doing this? This is just a box to be checked. Like, these are local comments. And yeah, you're probably gonna get some of those, but the state has taken it a step too far. And the other thing I want to address is there was an alternative method to this. And in the ABA comments, this goes to the second part of your question, 2 questions ago, regarding, if they think she witnessed tampered, can they bring a motion and ask the court for relief? The answer is yes. Okay, I think we can agree on that. The problem is in the way they characterized it and the statements they make in that brief. The second problem is it should have been, our position is it should have been done differently. And the ABA comments speak directly to it, and it's 8-2 point. Let me get there. I can only remember so many numbers. Point 1. And what it says is a lawyer participating in a criminal matter should not place statements or evidence into the court record or into a document that is deemed an open record under applicable law solely for the purpose of circumventing the standard. If the lawyer has reason to believe that the public release of the record or document would create a substantial probability of harm to the fairness of a trial or other overriding interest, the lawyer should consider seeking a sealing order pursuant to standard.
Pause there for a minute. In order for a violation of the rules to be material, it has to have caused irreparable prejudice such that due process is violated, she can't get a fair trial. So let's stay focused there. I'm just not sure we're at that point, given the amount of publicity that existed beforehand, what the comments probably said before all of this, the availability of other measures. Dismissal is the ultimate sanction. And correct me if I'm wrong, I don't think you cited a case in which the case was dismissed prior to trial for this kind of conduct rather than during trial. Am I right about that?
Or after.
Okay.
Correct. Candidly, I did not find a case that stated that.
I mean, can we just acknowledge
Yeah.
that during trial, the options are so limited. The jury's already in the
Right.
box. We can't re-inhale.
Right.
Jeopardy's attached.
Right. I think that is a different scenario. I think some of the cases, though, that came back on appeal, right? Like, it didn't get dismissed during trial. The conduct occurred, prior to trial. And those cases came back on appeal, for a new trial.
Those were embezzlement kickback, side deal, right? Not pre-trial publicity cases.
Correct.
Am I right about that?
Correct.
Okay.
So I do think it's nuanced, it's difficult in cases. I think we can all acknowledge that. But there is a process in place to ensure we can do the best we can, to take care that we all do the best we can, not to violate any of her rights to a fair trial. And the state, in their assertions and in the statements they have made, have not done that. And the prejudice is we can't undo that. Okay, this letter is out there forever, right? Whether it's ultimately admissible at trial doesn't matter at this
It
point.
matters a little bit, doesn't it? Because if it were to come
I mean, I'm
to
gonna argue it
trial.
matters because I'll probably move to motion to suppress it, but
Well, sure. Yeah,
Right.
So, I mean, but, I'm not expressing an opinion one way or the other
Right.
about any kind of motion in that regard. But imagine the letter came into trial. Any pretrial prejudice is now mooted. It's in. The actual jurors have seen it and heard it.
the problem is the statements the state has made during the pretrial phase, right? The statements that they have interpreted, this letter's open to multiple interpretations,
Sure.
right? And yes, we can get to that through cross-examination and
If it comes in.
at trial.
Right.
The problem is that there is local, national, global media where the state has interpreted the letter in the way they want and has put out to the world and all of our potential jurors that Kouri's lying, that her witnesses are lying, that her theory is false, that's the problem. The problem is their statements and the way they've interpreted it, and the prejudice to her is, you can't undo that. I mean, sure, we can probably ask people, questions in voir dire, but I don't think that's sufficient given the egregiousness of the statements. If it had just been, the way it should, in my opinion, the way it should have been done, or the state's or the defense's assertion is they could have moved the court for a motion for no contact order. They could have filed it under seal. They could have filed the letter under seal. We could have had this argument.
Yeah, or Kouri, you could have just not written this stupid letter. I mean, come on, you know that letters and phone calls are monitored from jail. She was in jail when this happened. This was a handwritten letter. It was a letter to her mom, not a story.
Or in a way that wasn't the state saying that she witness tampered. It wasn't the state saying that her witnesses lied. It wasn't the state saying she's guilty of murder. Those are the problems. And those aren't going to go away. Forever, there's going to be this issue that the states said that, and they can't do that. And if the courts, and I granted, dismissal is the ultimate remedy, right? But there are alternatives. I don't think any voir dire is going to cure this issue, given the egregiousness of the statement.
So I looked at your, or I should, the defense's proposed alternative remedies. I'm not prejudging a motion to change venue, but you haven't provided a basis to change venue. Yet the dynamics that we're talking about, as far as I can tell, exist statewide, nationwide. This case was covered by the BBC. I don't know that you will find a jurisdiction that is, certainly not the state of Utah, that is going to be materially different than Summit County in terms of its saturation with media coverage of this case.
Correct. I think there will be other grounds, and that motion will come. We're fairly early in the process of this, so I do anticipate moving for a change of venue. Based on I agree, unless we're going to some tribal land in Ghana, we're probably not finding people where it hasn't touched. But I think there are other issues that we will bring to the court's attention that we believe would support a change of venue. We don't need to get into that today, but I do anticipate that will be coming.
Then we have disqualification in the Summit County Attorney's Office, and I'm not sure why that follows. Here at this point, aren't they the most sensitized to the issues and the permissible bounds of what they can and can't say, rather than somebody else? Well, they've been involved. They're going to be subject to whatever ruling they make. I don't understand why disqualification of that office based upon public comments, conduct they've taken in prosecuting the case and making motions, rather than extrajudicial things like those things that exist in other cases that were discussed in the briefing of embezzlement, bribes, that kind of conduct. Here, if you're right that they violated some ethical rules, well, now they know, and I would remain confident they wouldn't do it again.
I don't think that cures the problem.
Tell me why though on a going forward basis. What is it about the continued involvement of the Summit County Attorney's Office on a going forward basis that would be prejudicial to this region?
I think if the court takes no action against the Summit County Attorney's Office, they're sanctioning what they said. And I think that adds additional credence to their statements. And I think that's a problem. Further, they've been involved in the investigation. Allow me a little more. Thank you. So, when they began investigating this case, I was having communication with the Summit County Attorney's Office. So they've been involved since the very beginning of this investigation and throughout it. And so they are intimately intertwined in the entire investigation as it went forward. Further, then they've said that this is our theory, there's no other theory, and the defense theory's got to be a lie because it doesn't fit with our narrative of facts, right? The problem is there's an insinuation that perhaps they drove the investigation, and this is where it ended up. And if it's
Tell me what you mean by that.
well, they made the ultimate conclusion that she's guilty in the briefing. Okay. And they were involved with the sheriff's office throughout the entire investigation, and they're saying that any alternative theory, say we go out and investigate and have investigators working and come forward with additional things or alternative theories or whatever, they've already said that can't be true because it's a lie.
Okay.
And because they drove the investigation or they were so involved in the investigation, I don't, maybe they didn't go look for any. I think the implications of—
It's a great closing argument regarding Ms. Richens getting railroaded, but I'm not sure that justifies by itself
I think
disqualifying the Summit County Attorney's Office.
I think in order to fix the narrative that the state has put out there needs to be drastic measures. And one of those could be, or should be, you messed up and you're off the case.
I understand that argument.
I mean, I think that is the only, the only way to correct the violations that we've alleged is to say, that they made mistakes, they violated the rules, and therefore they're not on the case. I think that puts us back a little bit to center where now we can go forward and we can present theories and there's a message out there that says, look, they shouldn't make those statements, they can't make those statements, and by disqualifying them, the office as a whole, I think it sends a message to potential jurors that that's incorrect. And that there's
Isn't that
potential.
problematic as well, though? Or we'd be sending a message, we would have to exclude all the jurors that had any sense of that, that were going to draw any conclusions upon that. We need potential jurors that were agnostic about that, wouldn't we? Meaning they didn't have an opinion one way or the other regarding the motives or conduct of any of the participants.
Right, but there's still, I don't think without proper remedies from the court, it restores Kouri's right to a fair trial.
Okay.
I mean, at the end of the day, we can't, doing nothing, essentially just adds credence to what they said, and she's in a place now where, you know, we can't call these witnesses, I mean, we're gonna call witnesses, but, you know, we're on the presupposed motion or assumption that, you know, the world is taken, that they're liars, because that's what the state said. And they can't make those, you couldn't make those in a closing argument. They couldn't get up there and say those things for a reason, right? So you should be able to say it now.
Well, I mean, let's be more specific about that. If they wanted to get up and say that, for example, Ms. Richens testified to X, Y, and Z, I think the state would be able to properly say, listen, compare X, Y, and Z to evidence A, B, and C. The inconsistency shows that X, Y, and Z is a false narrative. That is proper closing argument.
Right, but it'd be based on evidence.
Fair enough.
Right?
Yeah.
And you could, that is, I mean, that's what you advocate in closing arguments. You can say, you know, we presented this, the jury gets away with credibility of everybody's witnesses, including the defendant, and make their own determination. They've circumvented that entire process by saying it now. They predispositioned everybody to look at these people through a lens that they're lying, to look at Kouri through a lens that she's lying, to look at Kouri through a lens that she is trying to get people to lie for her, to look at counsel, frankly, through a lens that I'm doing improper, you know, I'm doing nefarious or criminal acts is what they've alleged. So that's the problem. They have essentially hit every single part of the rule that you're not supposed to violate. And the comment to 3.6 lays out things that are materially prejudicial. So I think that answers that question where they're making these statements now. 3.6 in the comments specifically says these things are materially prejudicial. And those are the things that they've done there.
Okay. I understand your position. It won't be the last time you get to talk. Let me hear from the state. Was there anything else you wanted to put on the record in the first place?
No.
Okay.
Well,
Mr. Blood.
Good afternoon, Your Honor.
State's briefing was a little general in terms of the way they've done anything wrong. There's no prejudice. Let's just move on. Address Ms. Lazzaro's argument that the things that the state said in its briefing related to the walk the dog letter are not the types of things that the state would be allowed to say in closing argument.
Your Honor, they are the things that be allowed to say in closing argument. It is fair argument, fair advocacy based on facts in the record today. And that's an important point here is that consistent with First Amendment jurisprudence on public access, consistent with the court's rulings on public access, these are public debates. These are the debates where the state makes its case in a filing. And the defense has an opportunity to rebut that case in the filing. They've just rebutted it, not only in the prior filings, but right here, right now at this podium. And that is fair litigation. That is how cases are litigated in criminal courts throughout Utah every single day.
Would you acknowledge that during jury selection, we will?
So I am just seeing that one page that we read out in the last live was just one of possibly 60 to 65 pages. So it might have been part of a novel, where she's writing after the fact, just like she did with her children's book on grief. Because I'm looking at an article here. I'll just read it. I don't need to show the screen. But it's dated from October 13th of 2023. Prosecutors say Kouri Richens was writing instructions to her family on how to testify in court. Richens' lawyers say she's writing a fictional book. Either way, the prosecutors say they now want the whole manuscript, all 65 pages worth. And it says, novel or not, this document became a flashpoint in the case, but Richens' attorneys claim the document is a fictional mystery novel in which Richens ends up jumping bail and going to Mexico. It is unclear how much of the book was written in prison. Summit County Sheriff's deputies seized part of the document on September 14th, finding it in an LSAT test preparation book. Later that day, court documents state Richens passed another 60 pages to her defense counsel, Sky Lazaro. Deputies did not search the manila envelope with the other pages. In phone calls made over the following days, Richens told her mother, Lisa Darden, and her brother, Ronald Darden, about the book. In both conversation, as noted in court documents, she notes that the walk the dog letter was simply one page of the full book to be called To Hell and Back. The manila envelope supposedly containing the book had been labeled privileged by Richens before handing it to her attorneys. Prosecutors say fictional works are not protected by attorney-client privilege. During this first week of October, court documents state prosecutors met with the defense to discuss the book. Prosecutors claim they reached an agreement that the defense would provide the manila envelope and the pages within, though they now say that has not happened. The walk the dog letter is the defendant's frantic, dishonest attempt to explain how Eric Richens may have obtained illicit drugs when all available evidence establishes that she, in fact, obtained the fatal fentanyl. And there are, by the way, texts, phone calls, so forth, proving that. Stated prosecutors in their petition to the court. The walk the dog letter illustrates the defendant's consciousness of guilt. There is every reason to believe that the remaining 60 pages of the fictional manuscript are as equally valuable as the letter. Prosecutors say they want the manuscript before Richens' next hearing on November 3rd. Okay. All right. So let's continue.
Need to identify jurors that have no knowledge of a whole long list of things, including the briefing and media coverage regarding the walk the dog letter and the manila envelope and any number of other things.
Yes, Your Honor. Undoubtedly, the court and the parties will select a fair and impartial jury. That will take longer than normal. That will take a jury pool larger than normal, an enlarged questionnaire, expansive voir dire. But there are people in Summit County who are not following this case, at least a dozen or so. And there are people, who we can't see as fair and impartial. Summit County Court set a jury on the Pouch Matter that received tremendous publicity. the court was right to note that much of this publicity is both national and international. More so probably than something else. I can think of 2 pending cases before this court, one civil, another criminal, that are receiving as much local ink as this case. And the court will see some accounting juries in those cases as well. As it relates to the walk the dog letter, and kind of this instant discussion we're having, the Algiers case that I don't know if you remember the state or the defense cites in its briefings, in dicta makes, I think, a pertinent note that the publicity at issue in the prosecutorial misconduct and retrial motion was kind of a drop in the bucket to the overall publicity of the case received over the arc of time. That's where we are here as well.
Okay. Anything else from the state on this motion? We have plenty of other ground to cover.
Your Honor, if your questions are answered, I will sit down.
All right, thank you.
Thank you.
Ms. Lismar.
There are a couple things I'd like to address.
Please.
With so interesting. The first point I'd like to bring up, and we addressed it in our briefing, is the state in their response briefing to this doesn't address really prejudice, as the court just noted. They don't address it at all. That they're, I mean, essentially, what they say is that maybe it doesn't matter, that this is out there and so be it. The next thing, I think it's important to look at the statements. The state is saying that they could say these things in trial. They could say these things, perhaps some of them, if they're supported by evidence in closing argument. What they can't say, and I think of a few of the ones that I think are particularly problematic, is, they first say that the court needs a no contact order to prevent the defendant from further engaging in witness tampering. Essentially implying that she's witness tampered before.
Right, but I come back to the hypothetical if they had just charged her.
But they haven't, that's the problem.
I know, but isn't that better for her?
Well, yeah, I don't want any more charges,
Right.
but I agree with you.
But is it a proper exercise of prosecutorial discretion to say, that is a distraction to prove that lesser charge? We're going to focus on the top level charges.
Well, of course they don't want any more charges.
Absolutely.
Jeez.
And I don't.
So the only reason I raise that is to say, in that alternative universe that I'm describing my hypothetical, the information, the preliminary hearing, all that stuff would be transmitting the message. She's a witness tamperer. That is not different than we have here. It might be worse.
It might be, but it might not be, and here's why. The state concedes in their brief that they didn't have evidence that she ever passed the letter or witness tampered, right?
Right.
So we would actually get to stand up here and say or cross-examine people to essentially prove that that wasn't true.
Well, that's probably
So,
not to
and I don't
too far
want
in
to,
the
yeah, I mean,
direction,
I don't
but
think that
why I'm
matters.
disinclined to prevent her from talking to her mother and her brother.
But the issue is that they have just declared that she's guilty of it, right? Instead of.
Is there anybody in the world that thinks the state of Utah doesn't believe she's guilty of the crimes for which she's in charge?
Is there anybody in the state of Utah? Well, I hope so.
Well, I guess, no, not that they believe personally, but that does anybody out there think the state is just doing this as theater? I mean, the state's position from the beginning is she's guilty.
Right.
I don't think they've been unclear about that.
No, but the problem is that they've used, the way they've drawn the inference between witness tampering and the ultimate decision that a jury is going to make in this case after it hears evidence is that because she witness tampered is a consciousness of guilt. She induced people to lie because she's guilty, right?
Isn't that similar to some of the arguments that we heard, on which I relied during the detention hearing regarding
I mean,
units of
she kind of did do that.
consciousness of guilt, trying to hide conduct? I guess what I'm saying is that why is making arguments regarding a particular piece of evidence, admissible or otherwise, showing consciousness of guilt, why isn't that a proper conduct rather than improper conduct, whether it gets media attention or not?
Because the rules specifically say that they can't comment on her guilt. The rules specifically say you can't comment on the credibility of her witnesses. The rules specifically, I mean, it's clear in the rules, it's very clear in the rules what you can't do, and that's what they've done here.
But you're not suggesting that the rules prohibit, as a matter of law, making an argument regarding consciousness of guilt in a pretrial finding.
I think when you tie it to the ultimate, I think it depends on the context, right? I think you could use this phrase consciousness of guilt in a number of different ways that doesn't say she's guilty of witness tampering, we're telling you she's guilty of witness tampering, and because she's guilty of witness tampering, she's doing it because she's guilty of murder. And that's what you can't say. You can't go that far. Yes, there are probably a number of ways you could argue that in different ways that may not violate the rules. But the way they've done it here violates the rules because they're specifically commenting on her guilt in this case. The other thing I'd like to address is the ABA standards essentially say there's different ways to do it. Like you could have done it under seal. This wouldn't have been an issue. She spent a vast amount of money. Taxpayers have probably spent a vast amount of money and time on this issue where we're not working, we're limiting our ability to work on other things. We're doing this. Ultimately, this rests on, or what's alleged violated jail procedure policy. As well, they make that determination, okay? The jail has internal remedies to deal with that. And the jail has decided that she recently violated one of those, and they have prohibited her from contacting her mother. So there were other ways to accomplish this goal without creating a media narrative for the state's position on her guilt and the credibility of the witnesses. And I think I just want to turn the court to the Hensley case. We relied on it in our briefing.
Is that the Fifth Circuit case?
It's a Fifth Circuit case.
That was during trial though, right?
It was.
Okay.
And I get that sometimes it's different. It can be different during trial because you didn't handle the jury. Those are the people who are sitting in it, right? I think that is different.
By implication, no other available alternatives to mitigate potential prejudice.
Correct. But it's still, and maybe these don't get litigated. I don't know. I mean, I don't know the answer to that. Maybe I don't know how many arguments I had. If this were a case without a lot of press, okay? If this were normal course, like my 60 other whatever cases I have, right, that are going through the courts, sure, we litigate things on the record, but nobody's looking at the record, right? It's not getting broadcast out to potential jurors. And so when you look at those types of cases in a normal course, it may not be problematic. I mean, it may still be a violation, but the prejudice may not be as grave as it is in this case. Because nobody would see it, right? The jurors, I panel juries all the time, and I have never heard of my clients and have no clue about anything that happened, and they go about the normal course of business. And so the only thing that's brought to their attention are the things that are said in trial. And so that's why I think we see most of the case law come from that, because that's how majority of the cases go. This case is different because this case has so much publicity. Greater care should be taken to ensure we're not tainting a jury pool, to ensure we're not saying the things in pretrial matters that we couldn't say at trial, because the effect is the same. We're potentially causing the same harm that would happen in those other cases to a jury when it's broadcast to the world, where we have, jurors that likely heard of it. And I don't think that the extent that the state has gone to in this case can be remedied short of, I mean, obviously we're here asking for a dismissal, but alternatively without grave sanctions against the state. And we suggest that they be removed and to start over or continue forward, so I should say, with a clean slate, in order to, put some order back in and, go back and ensure her fairness, her right to a fair trial. These premises aren't lip service. I mean, this is essentially the most important thing we can be arguing at this point, is whether or not we can ensure that she gets a fair trial. I think that ultimately is the most important thing, in a criminal case. It's, you know, the lofty reason a lot of us started doing this in the beginning, because we were going to be a champion for the rules. But, and I don't mean to make light of that. I think that's true for most of us who do this. But it is the most important thing. And so it can't be just, well, as the state says, like, too bad it's out there, we're just going to keep going, it's fine. It's not fine. It's not fine because they violated the rules, and the result of that is worldwide prejudice and a world that thinks that her liars and her witnesses and her counsel, you know, are going to misrepresent things to them or lie to them. And that's a hard thing to remedy.
Thank you for your position.
Thank you.
Thank you. The issue before the court is defendant's motion to dismiss due to prosecutorial misconduct. The gravamen of defendant's motion is that due to conduct by the Summit County Attorney's Office, defendant has been denied due process and her right to a fair trial. Specifically, defendant asserts that statements made by the Summit County Attorney's Office in briefing related to the walk the dog letter, briefing related to the Summit County Attorney's Office request for further limitations on Ms. Richens' ability to speak with family members, have included statements that violate Rules 3.4 and 3.8 of the model and Utah Rules of Professional Conduct. Those statements include things like, quote, defendant is engaging in witness tampering or needs to be prevented from further engaging in witness tampering. The motion for no contact was based on the defendant's witness tampering and breach of jail security procedures. The walk the dog letter illustrates the defendant's consciousness of guilt with respect to certain explanations made by the defense for certain actions that no such link exists in the evidence. That defendant concocts a false narrative. That defendant's own handwriting, she attempts to induce her brother to testify falsely. That she is facilitating witness tampering and supporting a false factual narrative. That she is giving her mother instructions to induce her brother to testify falsely. That this may indeed not be the first time the defendant witness tampered. And that defendant is making a frantic, dishonest attempt to explain how fentanyl came to be involved in this case. When viewed in isolation, these comments raise concern that they would cause undue prejudice by tainting the view of potential jurors in Summit County, the state of Utah, nationally, internationally, regarding Ms. Richens, her credibility of her counsel, and her ability to defend herself in a fair jury trial. But when read in context, and given how these comments are anchored to evidence in the record and motions made by the parties, these comments are within the bounds of professional conduct under Rules 3.4 and 3.8. These are examples of permissible advocacy on behalf of the state in support of its request for things like further limitations on Ms. Richens' ability to discuss, contact, correspond with certain family members, and also in response to arguments made by defense counsel related to other litigation topics. Moreover, before this issue arose relatively recently, this case had already received an inordinate amount of media attention, an amount so large that it is frankly not in the interest of justice. But the First Amendment works the way it works, and I can't prevent that. What the court can do and require counsel for the defense and the state to engage in is measures to mitigate any potential harm from publicity regarding the advocacy in this case on a going forward basis. And that would include careful, lengthy, and detailed voir dire jury selection, We will need to identify jurors that do not have any preconceived notions about the subject matter of this case or any of the people involved in it, the parties, counsel, witnesses, etc. That may be a lengthy task, but it was made lengthy long before this issue arose, given.
So that's pretty normal. It sounds like he's going to, probably deny the motion to dismiss the trial. Is going to side probably with the prosecution from the sounds of it. And just when they go to question, or when they go to the voir dire of during jury selection, just ask them if they've, pretty much heard about this case, heard about, the walk the dog letter, etc. And just, let the lawyers make their choice as to whether or not they want to select that juror.
Pre-existing publicity regarding this case. Moreover, these arguments would have been appropriate and without objection, the court expects, had Ms. Richens actually been charged with witness tampering. In that situation, the court would be making determinations about whether or not there was probable cause for the charge and there was probable cause to bind her over for trial. And these very same arguments regarding potential consciousness of guilt and materiality of the letter would have been made and would have been wholly appropriate. Here, based upon the briefing currently before it, the court simply isn't persuaded that the conduct of the Summit County Attorney's Office violates Rules 3.4 or 3.8, or has caused Ms. Richens a denial of due process or a denial of a right to a fair trial. The court is confident that it can preside over a sufficient voir dire process to ensure that Ms. Richens does in fact receive a fair trial. For these reasons, the defendant's motion to dismiss due to prosecutorial misconduct is denied.
Yes, I figured that might happen. And I have an article to read here to just kind of go over it. Its reason for denial. Give you guys a little more clarity. All right, so judge denies motion to dismiss Kouri Richens' trial. In Summit County, Utah, Kouri Richens, the Utah mother and children's book author accused of poisoning and killing her husband with fentanyl, appeared in court Friday regarding a motion to dismiss her trial, and the motion was denied. Kouri Richens' defense claimed that the state has perpetrated a false narrative through the release of the Walk the Dog letter, asserting that Richens will not receive a fair trial based on the public's belief that she was involved in witness tampering. Judge Mrazek refuted the claims, claiming the case had already received an inordinate amount of media coverage and that the coverage is protected under the First Amendment. He also denied the state's attempt to restrict Richens from communicating with her mother and brother, again citing the First Amendment. Additionally, the defense claimed that the Summit County Sheriff's Office should no longer be overseeing the case as they released the letter. The state claimed that the letter itself is an admission of guilt, or as the state referred to it, consciousness of guilt. The issue is that they have just declared that she's guilty of it, Richens' defense claimed. They continued to suggest that the state should correct the narrative by taking the Summit County Sheriff's Office off the case. The judge answered by saying that the state has every right to assert that Richens is guilty. The judge went as far as to say, is there anybody in the state of Utah that believes she isn't guilty? To which the defense replied, I sure hope so. The question implies that Richens' guilt is not the question here, saying the comments or the state's assertion of witness tampering are anchored to evidence in the record and motions made by the party. While the judge made it clear that the evidence is pertinent to the case, he said that the process of selecting unbiased jurors will be vital importance, and the process of finding them may be lengthy. And then here's what he said. You saw that. And then I also have a News Nation video. To look at that. Let me get this going here.
Again, thank you for doing this, and you're very kind to help the family out by doing these appearances. Are they relieved that the judge decided that the case would go forward? She would not get her wish to have the charge thrown out.
I think relieved is a good word, actually, but I don't know that anyone is particularly worried about that motion. The defense filed a motion asking that the case be thrown out because the state, the prosecution, had disclosed the walk the dog letter that you just talked about, and they disclosed that in a motion, as you also just talked about, to have her not be able to communicate with others on the outside because they felt that the letter was evidence of witness tampering, or at least attempting to coach a witness. So the prosecution said, hey, we think she shouldn't communicate. The judge says, no, she can communicate with with who she wants. The defense said, hey, they've leaked this letter. The judge says, well, she shouldn't have written the letter, and you're not messing up the jury pool, because exactly what you just said, Ashley, if Gwyneth Paltrow can get a fair trial in Summit County, then probably anybody can.
Or OJ or Beretta or you name it, Michael Jackson, everybody. I mean, so I would assume that the family is upset.
That's kind of a good point. OJ had an enormous amount of coverage prior to his trial. His trial was a huge, huge thing. And he even went on to write a book afterward. I believe it was titled something like, I didn't do it, but if I did, here's how I would do it, type of thing.
That she gets to maintain contact with her family after all of this.
Again, that probably wasn't a surprise. I mean, she has the right to communicate with her family. She just can't communicate with them in the way that she's alleged to have here, which is to encourage and try to get someone to testify falsely. Because the letter, if you read it closely.
And her mom, by the way, if you go ahead and review The Last Alive, her mom has had a big influence on her life. Her mom, I think, did quite a bit of controlling. I'm kind of excited to see if we can get any texts, any communication that she's had with her mom, prior to his death and afterwards, because they subpoenaed her mom's electronics, and I think they found a plethora of information. And her mom also has a history. She had a former friend, partner, that died of an overdose.
And it doesn't take rocket scientists to say that she was really trying to get her brother to say what you just said, which is that Eric was going down to Mexico and buying drugs, when everyone knows that wasn't true, but it would have provided a defense to the murder case.
You know, I always say, go ahead, chat away, write what you want, because every single thing you say and scribble is monitored, and it can be evidence used against you. So I'm always a fan of saying, open up the spigots of communication. We might get something good. But so let me ask you this. Families, you know, in any courtroom, especially one that is this tragic, there's usually a line down the middle with those who are supporting the defendant. Her family would be behind her. And then those who have the victim and their family, they're behind the prosecutors. And it can be very tense between families. What's it like in that courtroom?
It's exactly what you just described. I mean, there's an incredible tension. There are a lot of just viewers also, though. They're just people, as you know, for what you do for a living, that people just cover these things. People just show up. Onlookers just come, they want to watch. So there are a lot of family members from both sides. There seem to be somewhat sequestered from one another in the courtroom, but there are a lot of other people there that are just watching. And so far, it's not a big courtroom by any means. So far, there have been no outbreaks or any problems at all. I think the bailiffs are good about letting one family leave the courtroom first after the hearing is over, and then give them a few minutes to get out to the parking lot before the other family leaves. So the tension is there. The sort of the looks, maybe the glares, as you might expect, are going on. But so far, there's really, people have been very mature about the whole process.
It is a very dramatic reality getting into a courtroom like that. Greg Skordas, as always, thank you so much for helping us to sort of think through this and giving us the perspective from Eric's family. We'll see you again soon. Thank you for watching. Go to News Nation.
Okay, so next I have a video to show of Ronnie Darden, which this is the brother that in the Walk the Dog letter, she is instructing her mom how to tell Ronnie, or mom to tell Ronnie to tell her lawyers like what to say and so forth. So this is her brother, and he's going to go on to explain why he thinks his sister is innocent.
Mindy, my mother, DJ, I am Ronnie Kouri's brother, here with the rest of our family, my sister-in-law, Mindy, my mother, DJ, my beautiful wife and sister.
You can look at me too if that helps. Would that help if you give one person? Okay.
Just getting really worried for Kouri, for her emotional state at this point. She is being isolated from talking to almost everyone. She's not being allowed to have visits right now. Getting really worried with the way that she's being treated in there. We're doing our best to keep her, her spirits up as much as we possibly can. But at this time, we're just hoping and praying that she stays strong and that we get through this as quickly as we can.
Can you talk about her relationship with her children?
As of right now?
Yeah, and in general too.
As of right now, she gets 30-minute talks twice a week. Recently, they've been recording them for some reason, and that's about it. She misses her voice more than anything, and they miss her too. And being away from her, I think, is really taking a toll on her, or on them, excuse me. And it's becoming quite apparent. The allegations, they're hard to listen to, but at the same time, I know that they're just that. They're just allegations. They have nothing substantial on her at all. If and when this actually goes to trial, I have complete confidence that we have all of the proof to disprove everything that they're trying to claim.
What do you have to say about the letter that the state's really going after?
I think they're going after that pretty hard. I don't really have that much to say about it. From what Kouri explained to me, it was just a fictitious letter. I don't have a whole lot to really say about it. I think they're trying hard on that quite a bit because it obviously makes her look bad, even though there's several explanations for it. No, not at all. I've been outside of my mom and the closest one to their family, and because I know everything that went on there, I don't need to be said or convinced to say anything that's not true.
When did you first hear about the letter?
I heard from it right after it got reported. One of the reporters in Park City called me and started asking me about it. Didn't know what he's talking about, and started looking into it right after that. But that one kind of took me by surprise. And calling and not really understanding what was going on, and then obviously things started blowing up after that. So,
Ronnie, why are you so certain that Kouri did not do this?
Because I know my sister. My sister, she can't even squash a slider. She loved Eric. She loved her family more than anything. And I hate to say that, unfortunately, she's being painted in this light for really bad reasons, really selfish reasons. And so, we've got to get through that. Again, I know my sister very, very well,
Selfish.
and anyone that actually knows her, she's just incapable of doing that.
How would you describe her relationship with Eric?
They're great. They've been married for a long time, had some ups and downs, like everyone that has been together for a long time. But, up until very recently, next to his, just before his passing, they're in the best spot that I've ever seen them in. So, yeah.
Yeah, most ups and downs, though, don't include financial fraud, like hundreds of thousands of dollars.
Yes, yeah. She knows what's happening to her is it's unfair. It's not right, and she wants to help defend anyone else being put into her situation unfairly.
So if Kouri did not do this to Eric, how do you think Eric died with that family?
My thoughts on it is accidental overdose. That's my opinion. Could have been a number of things, but that seems to be the simplest answer to me.
Except that he didn't do drugs, with the exception of THC gummies. He was clean.
And that's typically what the right one is. The simplest answer is typically the correct answer.
Does that surprise you? Did you know that he was that or would want to keep it? Sorry.
There was a lot of talk today about kind of the public eye already trying this, coming up with a decision. Do you want to say anything about that? We're hearing from the family now for the first time.
Yeah, as far as the case goes, I'm 100% confident in how this is going to go. My biggest fear that we have is really finding a jury pool that hasn't already been taken by the prosecution.
Do you think she can get a fair trial?
I would find it very unlikely for her to do it in this county. Maybe not. Again, that is my biggest fear right now. Is that because of what has been put out by her by the prosecution, and typically the first thing that a lot of people hear is what they tend to believe. Unfortunately, there's been a lot negatively said about her, and we got claims to counter literally everything they're trying to say, but that's not being put into the public eye yet because we're waiting for court. And so I think it will be difficult and an uphill battle, but I believe in the rule of law. I believe in our court system and our justice system, and I'm sure that we will find the jurors that we need that will take an impartial stance on this.
How do you feel about today's decision with that, and also the no contact being denied?
I can't comment on that right now.
Okay. How often do you talk to Kouri?
Every day.
Every day.
Yeah, every day, a couple times a day. As much as I can, unless she's been thrown into lockdown, then of course I might get a few minutes a day with her. No. No comment on that.
I couldn't even hear what was being said.
She has her days. She tends to be in high school. She's got a lot of faith and a lot of trust in her attorneys, obviously, and we have the truth on our side. But obviously, some days are a lot harder than others. She misses her boys terribly, and her calling me, just bawling because she misses them. Is very, very difficult conversations, and they happen more than I would like them to happen, obviously. But she's saying as in good spirits as one could hope, given that she's behind bars. She hasn't done anything.
What is the biggest challenge with the family support?
As far as case goes and facts go, I don't see a problem. The biggest problem, again, that I feel that we're going to run into is a tainted jury pool. That is honestly my only worry as far as what they're going to try to bring forth as what they're going to call evidence versus the simplest explanations that we have. It just says how silly everything they're alleging is.
What do you want people to know about her?
First of all, that she's innocent. She absolutely did not and could never do this. She's been a model citizen of Summit County, in Wasatch County as well. She's an amazing mother. She's an amazing wife. Great sister, obviously, to us. And it just breaks our heart that she's going through this, but I think that she's strong enough to get through because she knows, again, the truth is on her side.
Okay. So that's that. And that's pretty much all that I'm going to cover today. I know in the last live I had talked about Eric Richens' sister has claims that Kouri had beat her. And she did say that in her, I guess you would call it like a witness impact statement on the last live that we went through when Kouri made her first court appearance. I wasn't able to find the time to do a deep dive into that. So I think I'm going to just do is I found a clip from Court TV that has her, that has that statement of her in court. So I'm just going to go ahead and play that and then call it an end for this live. And then talk to you guys afterwards.
Go ahead.
Dear Judge Mrazek, I'm here today to
Oh,
represent my
Mrazek.
brother, Eric Eugene Richens, whose life was taken in a senseless act of poisoning on March 3rd, 2022. His wife, the defendant, has been accused of committing this crime. If she is found guilty, she has committed the ultimate act of betrayal. Eric is gone, and I am brokenhearted. He was my best friend and protector. The feeling of loss is so great it is visceral. And with the sorrow comes a wave of panic at not being able to see him again. I can never talk to him, never hug him again, and never more be a part of his life. Eric's world revolved around his family, his love for hunting, the family cattle ranch, and his intense drive as a successful entrepreneur. Being born into the Richens legacy shaped Eric's formative years and resulted in a lifetime of hard work, dedication, and fierce loyalty. At an early age, Eric learned the joys of keeping horses and cows around. He spent countless hours helping our dad work the ranch, hauling hay, feeding the animals, and mending fences. He loved our family unconditionally and was a devoted son, brother, uncle, and father. Eric was a family man who always strove to be the absolute best father and husband. He was an attentive and loving father to his 3 sons and a devoted husband to his wife of almost 9 years, Kouri, the defendant. Eric did absolutely everything in his power to provide his family and his 3 sons with every possible opportunity to learn, grow, and have fun. He was the coach or assistant coach on all his boys' teams, which included soccer, basketball, and baseball. He spent countless hours coaching and teaching the boys to play aggressive and give it their all. Eric truly cared about every single child he coached and wanted the absolute best for all of them. There was never a dull moment when you were around Eric, whether it was him showing up to a family dinner with no socks or the sleeves torn off of his shirt because he had to make an emergency bathroom stop along the way, or his calling to tell you he rolled the 4-wheeler for the upteenth time is stuck and he needs you to come get it. It was never boring. Eric loved to have fun and always wanted to make sure everyone else did as well. He owned almost every motorized toy possible, from 4-wheelers and side-by-sides to trucks and snowmobiles, and was so excited to share those with his sons. He had the perfect combination of business sense and foresight. he built a very successful masonry business from the ground up and helped many friends do the same. He had a special ability to build close relationships with everyone he worked with, which really allowed his business to thrive. Eric loved every aspect of his job, but most of all, he loved the people he worked for and those he worked with. Eric faithfully supported organizations that he truly believed in. He never was one that wanted recognition or accolades. He did most things anonymously and without recognition. Eric was a true champion of all people. It did not matter if you were an employee, friend, family, or the next random person walking down the street. If you needed anything, you could count on him. He truly cared about each person he met. Eric loved fully, laughed loudly, and lived life with reckless abandon. He enjoyed great adventures to far-off places, but also cherished the small and finer things in life. No obstacle was too great for Eric. He simply viewed each one as a challenge. No peak was too high, and the next adventure was always just around the next bend. Words cannot describe the loneliness and loss that is felt in every heart that was lucky enough to know him. Eric was such an inspiration and role model for us all. His loss has created a Grand Canyon-sized hole in this community. Except instead of taking millions of years to slowly form, our worlds change overnight. His 3 boys' entire worlds and their perspectives on life changed. None of our lives will ever be the same. Eric died under horrendous circumstances. I am tormented at the thought of what he endured. I play it out in my mind. I go through the terrible sequence of events. I wonder when he realized he was in mortal danger. I wonder what Kouri may have said to him in his last moments. How long was he conscious, knowing he would die? Where were Eric's boys when all of this happened? Did they hear Eric's body fall to the ground? Did they catch a glimpse of their father taking his last breath? It's torture to think of. Why did Eric lose his life? Why did the boys lose their father? Was it because of Kouri's greed and desire to get life insurance and other assets? If so, that is abhorrent. How could anyone value life, human life, so cheaply? I cannot comprehend it. I'm overflowing with grief and pain at the thought that Eric meant so little to her. If Eric had died because of an illness, he would have been cared for. He could have looked after him and been with him. If he had died because of an accident, people would have tried to help. There would have been kindness. But there's no comfort to be had here. There's no consoling thought in the way Eric died. In his last moments, after being intentionally poisoned, he was faced with betrayal and terror. The thought of it is unbearable. I am haunted by the horror of it. This last year has been a living hell for our family. We have watched as Kouri has paraded around portraying herself as a living widow and victim while trying to profit from the death of my brother. Both by trying to profit from a book about his death and trying to get life insurance and assets that should go exactly where Eric wanted them to his boys. Immediately after Eric was killed, Kouri told us she could not help.
Yeah, there's some controversy in that. It was like a month prior, 2 months prior to his death. Something was going on with that, with life insurance, and I think I don't really know. I'm not going to say too much if I don't know about it, but there was something going on there.
Us get anything ready for the funeral, as she was too distraught with grief. We shortly found out that was not true at all. In fact, she pulled herself together enough to go close on the purchase of a $2 million home, hire a real estate agent, hire an architect to create CAD drawings of the home, hire a lawyer in order to file a lawsuit on Eric's trust, hire a locksmith to come break into and clean out my brother's safe, and attempt to have Eric cremated. She mustered up the strength and resolve to do most of this within 48 hours of his death. Kouri assaulted me. I will never forget the look in her eyes when she attacked me that Sunday morning. It was early and had been snowing most of the night. I was just getting ready to leave and heading out to the car when I saw a locksmith in Eric's detached garage starting to drill out his gun safe. I asked Kouri multiple times why we could not just call my dad for the code. I could not understand why she was breaking into and ruining Eric's safe. To this, she screamed at me at the top of her lungs, called me some inappropriate things I cannot share with you here, and then told me to get out of her house. It was then that I told her that she could not kick me out of my brother's house. My sister Katie, who was now the executor of Eric's trust and estate, and just like Eric, she would not want the defendant breaking into his gun safe. Kouri looked at me with pure hatred and rage. I was messing up her plan. I was getting in her way, and because of that, she attacked me. She punched me in the face and neck multiple times. It took 4 people to pull her off me that day.
Damn.
Before the funeral, Kouri opened a bank account and asked everyone that was grieving to send her money instead of sending the family cards and flowers. It was not even 2 weeks after Eric's passing that we were told she had taken down all but one photo of my brother and removed all his clothing from the house. Kouri put together a golf tournament in Eric's name 2 months after his death on what would have been his 40th birthday and told his family, all of us, that we were not allowed to attend. Since Eric's death, it has come to our attention that Kouri took out multiple life insurance policies on Eric without his knowledge. It appears that she forged his signature on various documents, assigned herself as Eric's durable power of attorney, inappropriately diverted money from his business to herself, and assigned herself as beneficiary of Eric's portion of our mother's retirement account. I should also not forget to mention the multiple life insurances she has taken out on the boys. Her most recent business venture was authoring a children's book about how to help grieving children cope with the loss of the death of a parent. In this book, she had the audacity to use the boys' real names and even use their last family portrait. Her behavior gives me great concern, as she has exploited the boys for money and will likely do so again. In addition, Kouri has weaponized Eric's children, manipulating my dad to do or not do things by threatening to cut him out of their lives if he did not capitulate to her demands. She similarly deprived the boys of contact with myself, my sister, and her daughters, unless we agreed to give her the money in Eric's trust, the money that Eric wanted to go to his 3 children. As if that were not enough, I have been told that Kouri started telling their 3 little boys that none of Eric's family or friends loved them. She apparently told them none of us cared for them or wanted to be around them, even though that is the exact opposite of what was happening. We all want nothing more than to be there for those 3 little boys, my nephews, yet Kouri has made sure to cut us out of every aspect of their lives. This is all just a brief summary and the start of what our family has been through over the last year. We have scarcely gone a day without finding out some new allegations or evidence regarding something Kouri appears to have maliciously done to attack and undermine my brother, his 3 little boys, and our family. We have all been there since the beginning of Kouri's and Eric's relationship. I was there on one of their first dates. We were there at the wedding. We were there when each of the boys were born. We have been there for every birthday party, school graduation, and rodeo. We welcomed her into our family and treated her as one of us. Not only did she betray our brother, it feels as though she has murdered and taken away a part of our souls as well. Because of her actions, there has not been a day that has gone by we have not lived with paralyzing anxiety and fear, worrying for the boys' lives as well as our own. I may be naive, but I never knew evil like this existed. If Kouri was in fact willing to kill Eric for money, who's to say that what she will not do? Who would be next? Kouri was in a desperate financial situation when Eric was killed, and that situation seems even worse now. We understand that she has defaulted on loans and is already a defendant in other lawsuits based on her financial misdeeds. I am truly concerned that she will stop at nothing to dig her way out of the problems, including murder. She seems devoid of moral sensibility, and there is no telling what she will do if she is released. Judge Mrazek, her fate lies in your hands. Please do not allow Kouri to use the fraudulent life insurance proceeds to get out on bail. That would be morally reprehensible. Please do not allow Kouri to take advantage and make a mockery of our justice and legal system anymore. She has done enough. Please do not allow Kouri to hurt Eric's memory, our family, friends, and community anymore. We have been through enough. Please do not give Kouri the opportunity to hurt Eric's 3 boys anymore. They have lost enough and have been through enough. Since Eric's death, we have learned and unfortunately are continually reminded that Kouri is desperate, greedy, and extremely manipulative. If she gets out on bail, I will be afraid not only for my own life and those of all of my family, but most importantly for the lives of Eric's 3 sons. Our family has already suffered enough. Please do not let Kouri out on bail where she will be a risk to do further harm. Please protect what Eric put his life on the line for, his 3 boys. Thank you.
Okay, so that is going to be it for this live. On the next one, we're going to continue with the timeline. Also going to get some information about a prior incident where they believe that Kouri had on Valentine's Day of all days, on February 14th of 2022, that she had made an attempt to murder him, to poison him on that date. So we're going to go over that because they do, the prosecutors do attach on attempted murder charge. And then we also want to discuss over the changing of her attorneys. And then I think there was another court appearance. Let me look. There was a motion to disqualify the prosecution. Let's see. Oh yeah, there's a preliminary hearing. So I have some things that I do need to gather and get put together for you guys. So probably won't do a live here for the next couple of days. Also need to get in, make sure it's cool with Triple L and Freddie. So getting everybody's schedules coordinated. So be on the lookout. I'll make a community post on my YouTube, which is at Willow's True Crime. You can also go to Willow's True Crime on X. Let me make sure that, Willow's True Crime on X. I'll be making community posts on there as well. All right, and I think that is it for now. All right, see you guys. Bye.